Welcome to DP Law classes. And personally, I welcome every one of my viewers to my channel that today on 6th November 2024 we have completed 1 year of our journey, and I would call it a pilgrimage to the ocean of knowledge that, as it was told by Sir Isaac Newton, the father of science and the ancient Greek political philosopher, and almost I would like to call him the father of philosophy, Socrates. So, almost we have completed 1 year of our pilgrimage to the ocean of knowledge, and in that we we have touched many aspects of legal thoughts, legal doctrines, legal maxims, legal philosophy, legal theory, and also some sociological aspects relating to legal framework, and also political science, as it is also an inherent part of legal science and legal theory. So, our emphasis is on jurisprudence, so also on the allied sciences and the subjects which are inherent. So, in that connection, we have discussed certain important legal theories exposed by some eminent legal thinkers, political thinkers, and philosophers. So now we want to enter a new arena, and where the very scenario that we want to enter is the international law. And regarding international law, although we have touched some aspects like state recognition, state succession, and nationality, now we want to go to another important area falling under international law, and that is extradition. So, what exactly extradition means and how it is being defined, and that is the main point that we would like to start from extradition and our new journey into another innovative and new field, and that is international law. So, extradition, as defined by Professor and international jurist Lawrence, and according to him, the surrender by one state to another of an individual who is found within the territory of the former state is called extradition, and according to Professor Oppenheim, and Professor Oppenheim was an internationally famous jurist of international law, and according to him, extradition exactly means delivery of an accused or a convicted individual to the state on whose territory he is alleged to have committed the crime. And now we will see how Professor J.G. Stark, another international law jurist, how he defined extradition according to Professor J.G. Stark. It is a process either under a treaty or on the basis of reciprocity. One state surrenders to another state an accused or a convict. So, from this we found exactly extradition revolves around a particular individual or person who is considered under law as a fugitive or a convicted person who committed such offenses and crimes which would be considered under international law as such a crime or offense. So, after analyzing the definitions, we would like to examine what is the position of extradition laws at present, as there is no uniform or universal law on extradition. Domestic and national laws or municipal laws regulate the principles of extraditions, which were enacted or are enacted by the domestic legislatures of respective countries. So also the decisions of the municipal courts or the domestic courts of a country are governing the very principles of extradition, as also bilateral treaties in between the countries also governs the very principles of extradition. So now we would like to discuss about the development of extradition laws and in particular how extradition laws were developed in the United Kingdom and in the United States of America and in India. So in that regard, first let us go to United Kingdom. So the English Extradition Act of 1870 allows surrender of a person only if there is a treaty obligation. So, if there is a treaty obligation in between the bilateral countries or in between two countries, then extradition would be possible and there would be possibility of surrender of the convicted person or the fugitive person who is alleged to have committed certain crimes. It may be political crimes, may be military crimes. So, now we'll examine the very development of extradition laws in United States of America. And the American extradition laws hold the same view as we found in the English Extradition Act of 1870. But as United States of America is a party to the Montevideo Convention on extradition, And the very convention was held in 1933 in Montevideo. So it has to surrender an individual to a member state of that convention or if committed any punishable offense. So almost all Latin American countries in Southern America and United States of America were the parties to the Montevideo Convention of 1933. And now we'll examine how a tradition treaty developed in India in prior before independence. All the extradition cases were governed under the English Extradition Act of 1870. But after India became independent in 1947, the government of India enacted the Indian Extradition Act of 1962. And the Act, under Section 31 of the Act, it restricts surrender of individuals of political character. Further, the central government by notification or order can surrender criminals to Commonwealth countries if there is extradition arrangements. So the very provision under Section 31 of the Indian Extradition Act of 1962, if you examine in detail, it provides surrender of individuals of all kinds of offences committed, but not of political character or political offences. In that connection, we could cite an example of King Tribhuvan of Nepal, who took asylum in the Indian diplomatic mission in Nepal when a revolt was started against his dynasty in Nepal, and he was considered as a political offender. So, as per the provision of Section 31 of Indian Extradition Act 1962, the Indian government would not surrender anyone who took asylum and a political offender. And as regarding Commonwealth countries, as India is a member of the Commonwealth of Nations, so all those countries who were under the colonialism and imperialism of United Kingdom after the end of colonialism and imperialism got independence, they formed the Commonwealth of Nations. And as per the provisions of Section 31, there is the deed of treaty arrangements among the Commonwealth countries regarding surrender of any fugitives. So, now we'll go to the regional conventions which were held in regards to extradition. So, the first such conference was held by the Pan American Conference of 1902. Then the Montevideo Convention of 1932 among the Latin American countries and United States of America. Then the Asian African Convention of 1960. And in 1965, the Conference of the Commonwealth of Nations regarding extradition laws. And so also in 1962, the Arab League Conference among the Arab countries were held in regards to extradition. So also we found that the Arab League Convention of 1952 among the Arab League countries, they adopted some extradition rules which also laid foundation for the development of extradition laws at regional level. And then the European Convention of 1957, which evolved certain extradition laws among those European countries who were parties to European Convention of 1957. Then the Geneva Convention of 1936 for suppression of illicit traffic in dangerous drugs requires a state to surrender an individual committing such crime. So the Geneva Convention of 1936 exactly stipulated that any person or individual involved in drug trafficking, which is considered as dangerous, must be surrendered by a party state who is signatory to the Geneva Convention of 1936. So also we found that attempts were taken by states at the international level as the International Law Commission drafted on extradition laws in 1949, and that draft of the International Law Commission on Extradition Laws, even though drafted, but as it was not uniform according to some state parties, so it failed to materialize. So almost we have expressly discussed about the provisions and the way of development of extradition laws from regional conventions. So now we want to discuss extradition of political offenders. So as regarding political offenders, now we want to discuss the very provisions of Article 120 of the 1793 French Constitution and also Section 31 of Indian Extradition Act of 1962. And the very practices among modern states, they do not allow extradition of political offenders. So now the question arises, which particular offense would be categorized as political offense? And how political offenders would not be extradited by a state? In that connection, we would like to discuss some important leading cases in relating to extradition. So, in that connection, first we will like to discuss the Castion case of France, a Switzerland. So, exactly in this case, the very person or individual who was demanded on extradition by the Switzerland government was a person who committed certain political crimes in the very canton of Ticino, and it was a canton of Switzerland in the year 1891, and after committing the political crime or offense, he escaped and surrendered in United Kingdom or Britain, and as Switzerland demanded his extradition, it went to the Queensland, and the Queensland denied extradition of the Castion as because he was a political offender. So, in another important leading case, also you want to discuss, that is the Meunier case, where Meunier was a French anarchist and he was charged with causing explosion in Paris, and after that he escaped and took shelter in United Kingdom, and that we could say took asylum in United Kingdom. And when the French authorities demanded his extradition in 1894, the Queensland allowed extradition as because Meunier was an anarchist, and every anarchist, they don't want any type of government and state which is against law. So also by causing explosion in a Paris cafe, it would not be considered as a political offense. So the Queensland allowed extradition, and by allowing extradition, the Queensland formulated certain principles of extradition to be followed, such as there must be two or more political parties in the very contention and conflict, and the act committed by the individual must be political in character. And the third principle laid down by the Queensland, the very purpose of the act committed by that individual must be having political object. And the fourth one, the four principles made by the Queenslands that there must be political struggle or political uprising and movement or any kind of political disturbance in which that particular individual was involved and engaged, and in such case it would be considered as a political offense, and in such cases such individuals could not be surrendered to the very request of the countries demanding their extradition. And in that context, we could like to discuss certain Indian extradition demands as in long before independence in 1910 when Bir Savarkar was an extreme nationalist in the national struggle, was found guilty of committing treason and some serious offences. He was taken by the British authorities for his trial in India in a boat from United Kingdom to India. In between, at the port of Marseilles in France, he escaped. But when he was found by the French authorities, he was handed over to the British authorities, and later on the French authorities demanded his extradition on the ground that Savarkar was a political offender, and as such the British and French authorities went to the Permanent Court of Arbitration at The Hague in the same year in 1910. And after hearing both the parties, the Permanent Court of International Arbitration at The Hague disallowed the extradition of Savarkar to the French authorities. And in the same way, we could like to discuss another important case leading to extradition, and that was the case of Dharam Teja, who was the managing director of Jan Shipping Corporation, and after he took lot of money of the company or the corporation, he fled away to Ivory Coast. And the government of India, when it came to the knowledge of the government, demanded the extradition of Dharam Teja. But as India was not having any extradition treaty with Ivory Coast, so Ivory Coast refused to hand over Dharam Teja. And after certain time, Dharam Teja was traced in London, and the government of India demanded his extradition from the British government. And as India is having an extradition treaty with the government of United Kingdom, so ultimately Dharam Teja was extradited to India. And another important, and I think the most important leading case relating to extradition is the case of Abu Shalem and Monica Vedi. Abu Shalem, one of the fugitives of the Bombay blast case of 1993 and was the mastermind of that bomb blast of 1993 and a disciple of the underworld Don Dawood Ibrahim escaped to Portugal, and when the government of India demanded his extradition, as India was not having any extradition treaty with Portugal, so the Portuguese government refused to hand over Abu Salam and Monica Vedi to the Indian authorities. So, the government of India, as its agency, the Central Bureau of Investigation (CBI), cited the existing United Nations Convention on Suppression of Terrorism, which was enacted in 2000, to which both Portugal and India are signatory. So, on that basis, Portugal have to hand over Abu Salam and Monica Vedi to the Indian authorities. And in that process, the Supreme Court and their Lordship of India, they interfered, and ultimately Abu Salam and Monica Vedi was extradited to India on the condition that the Indian executive or Indian judiciary would not award them any kind of death sentence. So these are the important leading cases relating to extradition. So now we'll deal extradition of military offenders, and in that connection we have to discuss such offenders committing war crimes and genocide are coming within the very definition and meaning of military offenders. So, all the Nazi military personnel and also all the fascist military offenders during the Second World War under the rule of the then German Chancellor Adolf Hitler and the fascist ruler of Italy, Benito Mussolini, all crimes were considered as war crimes, and all mass killings by the Nazis and fascists considered as genocide. So, any individual involved in such genocide and war crimes should be considered as military offenders. So also, when the late ruler of Uganda, Idi Amin, and Nawaz Sharif of Pakistan were in Saudi Arabia, their extradition was also demanded. But in particular, regarding Idi Amin, the late former president of Uganda. He committed genocide in Uganda, and also regarding Pol Pot, the former ruler of Cambodia, the present Cambodia. He committed also genocide which were falling on under military offense. So while Idi Amin escaped to Saudi Arabia and took shelter there, and Pol Pot escaped to London and took shelter there. So we found other many instances such as the Shah of Iran after the 1979 Iranian Revolution. He also escaped to United States of America, and he committed military offenses and war crimes. So also Ferdinand Marcos, the late former president of Philippines, who committed genocide and war crimes, also escaped and stayed in United States of America. So these are the categories of military offenses. So also we found after the First World War, the extradition of the late ruler of German William Kaiser, or the late emperor of Germany, who escaped to Holland, and his extradition was demanded by German, but Holland refused on the ground that as it was not a party to the Versailles Treaty, so Holland was not bound to extradite the German Emperor William Kaiser. So, after all these developments, we would like to discuss the present position of extradition. So, the United Nations Organization made a declaration in 1967 regarding a model treaty on extradition, and that model treaty on extradition by the General Assembly was adopted in 1990, and so also the Indian Extradition Act was amended in 1993 and again in 2001 to meet all those requirements as per the time and circumstances and of the changing scenario. And as we found as regarding the case of India, as it reached extradition treaties with many countries, such as with Canada in 1987 and with United Kingdom in 1992 and with the Russian Federation in 1998 and with the United Arab Emirates in 1999, so also with United States of America in 1999 and also with Spain in 2002, and with France in 2003, and with South Africa in 2003. So, these are the developments in regards to extradition laws. So, we have touched the very definition and meaning of extradition. So, simply, in simple terms, if we define extradition, then exactly in ordinary words it is called surrender of a fugitives or handover of fugitives. So, we have touched all the definitions regarding extradition and the developments of extradition laws. And also we have touched how extradition laws developed due to regional conventions. And ultimately we have discussed extradition of political offenders, and in that connection we have discussed the most two important international cases in between France and Great Britain. One is the Castion case and the second one the Meunier case. And in connection to India, we discussed the very important case of the Savarkar's case of 1910. So also the case of Dharmteja, and also the most important case that is relating to extradition of Abu Shalem and Monica Vedi from Portugal. So we have completed our lecture on extradition.